Obviously, paramount consideration is given in these cases to the best interest of the child. I think that these courts have referenced it as the most important paramount decisions that courts can make. Our state has developed and revised those parameters for establishing best interests, and one consistent overarching goal in these cases is to provide for the child's safety and well-being. This is a case that is an unfortunate case, as all termination cases are. This child was born on June 18th, 2020, to Emily Thompson and Brennan Tucker Henry, and had a very difficult start. Suffice it to say that the child was moved around several times, and then at some point came into the custody of Brian and Samantha Thompson from South Carolina, where the parties were living, presumably to try to rehabilitate themselves from both drug and criminal histories. At that time, the Thompsons made a very difficult decision to take next steps to do exactly what our state has tried to do, and that is protect and provide for, in this case, this child's safety and well-being, and file this action. When the child was received by the Thompsons, it was done so with the blessing of the mother. The father had moved to Florida, and eventually the court, in various proceedings, ultimately decided both on the juvenile court level and the circuit court level that it was in the child's best interest to remain with the Thompsons pending these proceedings. When the child was received, he was low in terms of his weight, low in his physical and ambulatory skills, and was developmentally delayed, which caused the Thompsons, partially caused the Thompsons to go in and proceed with the termination and adoption. And since these proceedings have commenced, the mother unfortunately did succumb to her addiction, and the father, who was in the case very early on, ultimately basically disappeared for a period of a couple years before he showed up at trial. Now, he did file some things with the court, a couple of requests for appointment of an attorney, both of which were denied because the court found, rightfully so, that he had the ability to hire an attorney if he would work. What we're asking today, Your Honor, after the trial of the case, the trial court did find grounds for termination as to Mr. Henry, but did not find that the best interest of the child would be served by terminating. What we're asking this court to do under In Re Gabriella D 531 Southwest 3rd 662, that states a trial court's determination as to the existence of clear and convincing evidence supporting termination of parental rights as a conclusion of law, and thus is reviewed de novo with no deference to the trial court's decision, and the appellate court will make its own determination as to whether the facts provide clear and convincing elements necessary to terminate the parental rights. What we're asking the court to do is to review those facts, reverse the trial court, and terminate Mr. Henry's parental rights so that the Thompsons can proceed with the adoption. In doing so, the elements are listed in TCA 361113I, and those were explored in court. There was very little that was rebutted by or challenged by the father. He indicated that in terms of his adjustment of circumstances, he did not have a job or home at the time of the action was filed. He did not have a job or home necessarily at the time of the trial. He said he was working about 20 hours a week, but he was living with his cousin. He moved around. He had 6 different addresses in the last 2.5 years. He has an extensive history of drug use and criminal activity, which has permeated both before and throughout these proceedings. In fact, he was out on bond for aggravated domestic assault and a DUI at the time of the hearing. The trial court, unfortunately, as our position, failed to give sufficient weight to Mr. Henry's history of drug use and the fact that he could be incarcerated in the future due to those pending charges. Even Mr. Henry himself, under oath, testified, quote, "I'm definitely not fit to have him, the child, in my home or anything." He testified he'd not been able to get back on his feet since leaving Hilton Head, South Carolina, was not in a good place and not doing well. Now, this is over the course of 2 years. Time this pleading was filed until the time we heard the trial, it was 2 years, and he still wasn't on his feet, still wasn't working well, still did not have a house, a job. There was no evidence, frankly, and he didn't try to rebut that he was doing anything at that time to remedy his situation. In terms of maintenance or regular contact or visitation, Mr. Henry actually lived with the Thompsons for a period of time. He knew where they lived. They had not moved. He had all of the contact information in terms of cell phone numbers and text numbers. In fact, for a period of time, he was FaceTiming with the child, but he stopped. And he said under oath that he stopped. Actual last in-person contact that Mr. Henry had with the child was February of 2021. The last communication he had at all was sometime in June of 2021. He's failed to establish the existence of a meaningful relationship. And of course, Mr. Henry, in his response, indicated that he was blocked or somehow prevented from seeing the child. However, it was shown very clearly that he had the opportunity, the knowledge, and the know-how to file things in court, specifically affidavits. He filed motions on his own pro se. He was also represented by counsel early on. He never filed a motion for parenting time. He never asked the court to establish any kind of temporary time during the pendency of this case, which he had the opportunity and the right to do so. Unfortunately, the trial court, on hearing the testimony and the evidence, accepted Mr. Henry's version that he had been blocked by the Thompsons, even though the Thompsons opined that they had not. And they didn't. He did not. The trial court did not place any responsibility on Mr. Henry regarding his ability to seek visitation during the pendency of this case. He did not take any steps and has not taken any steps to reinstate a relationship with the child, and he has failed to establish any relationship, much less a meaningful relationship, which weighs heavily in favor of termination. Number 5 is the effect of change on the child. I think this goes without saying. It was undisputed that the courts in Tennessee have affirmed the findings of potential change of caregivers and physical environment supported parental termination for a parent without a meaningful relationship with the child. Obviously, in this case, there was testimony by both the Thompsons that it would have a terribly detrimental effect on the child. The child was 8 months old at the time the father left for Florida, and he hasn't seen him since. Evidence of prior abuse and neglect. While the court did not apply this factor, we felt that that was an error. We feel that the evidence presented specifically that the child was not properly cared for during the time he lived with his parents in Hilton Head, being of low birth weight, ambulatory issues, being somewhat in a retarded developmental state. We feel that that should have risen to the level of sufficing the requirements of the element of evidence of prior abuse and neglect. Pediatrician confirmed that the child was not doing well, and since the child has been with the Thompsons, he has progressed and is now doing very well, both physically and emotionally. Physical environment of the parents' home. Obviously, the trial court noted that Mr. Henry's history of drug use could impact his ability to care for the child, and that and the trial court also found that Mr. Henry failed to denote any steps that he would take or could take to make sure that there was a home suitable for the child. So that, again, favors and weighs in favor of termination. The parent's mental and emotional health. Mr. Henry testified that he was, quote, not in a good place, quote, and, quote, not doing well, and he was on medication for a mental and emotional condition that was not disclosed to my recollection. And finally, it was the payment of child support, which was undisputed, nor was it refuted by Mr. Henry that he had never tried to do anything to support the child financially prior to the filing, but he did opine or testify that he had spent $91 at Amazon sometime in late 2021. I think what the court should also note is that these factors were specifically addressed by the guardian ad litem for the child in his closing, and that because Mr. Henry did not support the child financially, Mr. Henry had no home, that he had pending criminal proceedings against him, and he had not seen the child in over 2 years, nor had he attempted to change his circumstance in any way during those 2 years, and that the child had formed such a close bond with the Thompsons, he recommended to the court that termination was the appropriate step. Add together with Mr. Henry's own testimony and his own admission that he was not presently fit to parent the child, and he presented no evidence of when or how that may change, we believe that the trial court erred in not taking those factors in the totality and finding that by clear and convincing evidence that termination of Mr. Henry's parental rights was the right move.
Good afternoon. I'm Catherine White, and I'm representing the biological father. Due to the limited time that we have, I would like to go ahead and launch into my cross appeal. I would reserve 2 minutes for rebuttal as the cross appellant. No? Okay.
Go ahead with your argument.
All right, I'll go ahead and launch into my cross appeal then, Your Honor. Thank you. I would note that my brief in detail addresses the best interest analysis, and I tie it in closely with the transcript and the exhibits. I believe that if you look at it and evaluate the conduct of the grandfather in blocking contact and doing some of the things that he did, that the trial court had reason to find that that canceled out any kind of benefit on behalf of the petitioning grandfather in doing the analysis. But aside from that, the issue I want to bring up is, number one, whether or not there was an erroneous finding that the grounds for termination for failure to pay 4 months prior to the filing of the petition for termination, thus resulting in abandonment, existed. First, the record is clear and absolutely not conflicted at all that my client lived with this child from birth all the way up until about 1 month before the petition for termination was filed. He lived with the child, the mom, on a consistent basis. He was asked to leave when they were residing in Hilton Head with great-grandmother and great-aunt. When he left, the testimony shows, consulted with 2 attorneys to find out what to do, because while he was established by an acknowledgement, he was not, there was no court order yet that would allow him to take his child with him. So it was a matter of 2 weeks. Actually, it was about 16 days from when he left Florida, or excuse me, the home in Hilton Head, and filed his own petition to establish paternity and parenting rights, or I would say a parenting schedule. Well, in the interim, let's back up a minute. I think the question I want to ask you is, how is it that you could be deemed obligated to pay or provide support when you're still living with the child and the child's still living with you? Even the child support statute and guidelines are set up and anticipate that there is a separation of the parents of the child. I would submit to you that it requires a leaving, if you will, in order for the abandonment to ripen at the end of 4 months for non-support, non-payment. I have cited an interesting case in Re Elena B. It's a Tennessee Court of Appeals 2021, where the Court of Appeals held that the allegation that the father had abandoned the child by failure to support was nonsensical in light of the fact that father undisputedly had legal and physical custody of the child in the 4 months preceding his incarceration on July 22nd, 2019. It is unclear, therefore, to whom father would have made support payments during the correct 4-month period. As such, the Court of Appeals vacated the trial court's determination that the parental rights should be terminated for abandonment for failure to support. The second issue, as it relates to this, I want to point out, is that the party, my client rather, and the mother and the child and the great-grandmother and great-aunt had moved to Hilton Head to get away from COVID. It was at its height, and they were trying to keep the elderly ladies and the baby from getting sick. The testimony, the proof, and the records uncontradicted is that my client was forbade from working. They did not want him going out, bringing the virus home, and so he did not. The whole family supported this. And as a result of that, he had used his student loan money, he was going to school remotely, to buy things for the child, a car seat, toys, a pacifier. But the point would be, is that token or was it not when you consider his limited financial ability and the fact that COVID was going on and he was told to stay home to keep everybody, particularly the elderly ladies and the baby, from getting sick. The third thing I want to point out is he did file a petition to establish paternity and this parenting plan February the 22nd. That was 16 days after he was asked to leave the Hilton Head home in the Juvenile Court of Hamilton County, Tennessee, having talked to 2 lawyers. This action I would submit is hardly that of someone who has abandoned their child and doesn't care. He was trying to get him. And then 1 week and 2 days before or after that, the termination petition was filed by grandfather in the Circuit Court of Hamilton County. So to just put it in perspective, on February 22nd, my client filed the petition to establish parentage and a parenting schedule. On February 23rd, he got an emergency ex parte order from juvenile court. And then 2.5 hours later, grandfather swooped in on February 23rd, based on a petition that we submit was riddled with falsehoods, got an ex parte order of protection, order of custody. A hearing date was set for March the 4th. Well, the next thing we know, on March 2nd, Grandpa hurriedly married his live-in girlfriend. On March 3rd, he hurriedly filed, they too, now that they've married, a petition for termination and adoption, thus thwarting the hearing in juvenile court on March 4. My client never had a chance to address the allegations. But I would note, because the proof shows that these allegations were false or grossly misleading, and those allegations have continued to contaminate this entire proceeding, we're asking you to consider awarding my client attorney's fees, especially if you ruled that termination, that there were no grounds to begin with, and certainly not terminating was appropriate. We believe that is appropriate because of the things I just told you about that's proven in the record. And then lastly,
Do you have any authority that would allow us to do that?
Rule 11, contempt,
Did you
sanctions.
file a Rule 11 petition in the trial court?
I wasn't involved then, and we didn't know it was a lie until after the trial happened.
Rule
But
11 procedures are very specific, as are the contempt procedures.
let me rephrase. By an analogy, and I think I misstated, I did, there is an obligation to tell the truth. There is an obligation to know what you're filing and that you're not filing it just because. In light of the fact that we have proof that it was false, I want you to consider awarding sanctions because it's still a lie on the court. Whether we go, apparently we
Do you
can't
have any authority that this court can award sanctions sua sponte?
Let's see. I think I did find it in the rules, but I don't have it in front of me today. So that doesn't help me, does it? All right. From an equity standpoint or from other standpoints, I would say unclean hands does not mean that someone...
Have you made these arguments in your brief?
Some of them, yes, sir. I did, actually. Now, lastly, I would like to ask you to consider to remand, if you uphold what happened with no termination, you remand this case to the trial court and ask him to fashion an order that will allow my client to see his child with safeguards if necessary. He's not terminated, and there was a pending petition to establish parentage, and under the rule that I cited, specifically it says if a petition has been filed to establish paternity of the child who is the subject of the adoption proceeding, the adoption court shall have exclusive jurisdiction to hear and decide any paternity petition filed in the adoption proceeding or that has been transferred to it. And then it also says that if termination does not occur, if grounds for termination do not exist, then the child's legal father shall be granted custody of the child unless the court determines upon clear and convincing evidence that the legal father is unable currently to provide proper custodial care for the child. And we're admitting to that right now. I mean, we don't think that it's appropriate to wrench the child away from the grandparents and put the child with my client. We'd like a warm-up period at least, some kind of integration at least, which the trial court can do. But in which case the court shall make such orders as may be necessary for the child's care and supervision pursuant to TCA 37-1140. So in conclusion, we're asking that you uphold the court for not terminating. I'm asking you to determine that there were no grounds to terminate based on abandonment anyway. I'm asking you to consider attorney's fees for my client, and I'm asking you, if you remand it, well, you'll remand it anyway, but when you do, that if you find that termination should not have occurred, that you'll ask the trial court to fashion an order so my client can see his child. Thank you.
I believe you have 3 minutes.
Thank you, Your Honor. Just quickly to address the abandonment issue, the only evidence or testimony that was offered that Mr. Henry did anything for this child financially at any point in his life did not occur until sometime in 2021. He may have lived with the child for a short period of time, but he was asked very specifically at trial about what he did to provide, and his answer was that he changed a diaper and that he blew on the child's belly. That was it.
What about the fact that, and I'll have to look at the record on this, but I mean, he was, it's my understanding, the child's caregiver at the time they were in Hilton Head. And if he was in fact the caregiver, who's he, what's he supposed to do besides care for the child?
That was his own testimony that he was the caregiver. That was refuted in the previous hearing by both of the ladies that lived there and by the mother. They all testified in the prior hearing that he would sit in his room and smoke marijuana most of the day. So, and that's why Ms. White's argument fails, is because he was there. The child was actually being cared for by these 3 other women.
Did the trial court make any findings about what you've just said the evidence was?
Well, yes, the trial court found that failure to support was the grounds for termination.
Yes, I understand that, but the allegations that you've just made about what the witnesses testified to, about the disputes?
I don't think,
He was the caregiver. They said, no, he wasn't. He was doing other things.
I don't recall specifically, Your Honor, if our trial court found one way or the other on that issue. I don't recall. I know that he asked for the transcript from the hearing that Ms. White relies upon heavily in her brief, which was Judge Hollingsworth, who, he did, her argument was that this petition was filed in juvenile court. He never had a chance to refute these allegations. The fact is, there was a full-day trial for temporary custody where all of these things were brought forth before the court, all of these things about where they lived and the circumstances and the Thompsons and the ultimate judge that was presiding before Judge Demetriou came in ruled that the child should stay with the Thompsons. So all of this stuff these rocks that have been thrown were fully assessed by the court, analyzed by the court, weighed by the court, and the court found on every level that the child should have stayed with the Thompsons. And that's where the child has been ever since.
And there's a transcript in the record of that hearing?
I believe there is, Your Honor, yes. We filed one. The trial court, the secondary trial court, the one who took over for Judge Hollingsworth, requested it, and I filed it, and I believe it is in the record.
All right, sir, you used your time. Counsel, we appreciate your arguments and briefs. We will take this matter under advisement and attempt to render an opinion at the earliest possible time.
Thank you.
You certainly may. You may be excused. We will be in recess to the call.